Hello, my name is Jiacheng. I'm a lawyer and I work in Guangzhou Jiacheng law firm in Yunnan, China. The paper I will be presenting today is titled Suggestions regarding the WTO dispute settlement mechanism in strengthening multilateralism. Let's see the outlines. First, I will give you some introduction. After that, I will show the force of DSU mechanism and the reasons of causing the force of DSU mechanism. After that, I will provide some suggestions of resuming the function of DSU mechanism. And after all of this, I will give a conclusion. So let's see what happened during the pregnant period of U.S.-China trade war. The U.S. announced its plannings from 23 March 2008. They said they will propose additional tariff on certain Chinese products. They said that in 23 March 2008, for April 2008, and 19 June 2008. You see, they just list some goods they will impose the tariff, or they propose. They will propose to leave an additional tariff on Chinese products, and as well, China take some countermeasures, like they notice the U.S. government they will impose the the possibility of imposing additional tariff on U.S. exports. However, during this period from 22 March 2008 to 6 July 2008, they didn't impose the extra tariff on each other's exports. But the situation changed at 6 July 2008. At this day, U.S. imposed a 25% additional tax on 4 billion of Chinese products. As well as China, they levied extra 25% tax on 13.4 billion U.S. exports. So we can see from this 23 March 2008 to 6 July 2008, it's about 74 days. And what the other measures that the two governments take, and the U.S. submits a request for talking to WTO to search a peaceful resolution from WTO. That is the case DS 542. It's about the China IP rights too, and as well as China, they submits their consultations with the U.S. states. That's happened at 4 April 2008. That's the case DS 543, and the case DS 544. About the tariff measures, the products, so those three cases, it couldn't stop the outbreak of U.S.-China war. Why? Let's see some reasons. First, we could see the timeline. The first case, that is last more than 200 days, and the second is more than 2 years, third 2 years, more than 2 years, more than 2 years, and more than 2 years. Except these two cases, DS 563 and DS 565. Those two cases, I couldn't find some useful information from the WTO website, so I couldn't give certain information about those two cases. And as well as the newest case, DS 597, it's next 2 years. So all those cases is consumed. Those of them takes more or about more than 2 years. Yes, that is largely longer. Largest longer than 17 days. So it's not too harder to figure out. The WTO dispute settlement is not competent to deal with the trade conflicts timely. And let's see the situation, present situation of these 8 cases that Chinese and US submitted to the WTO DSU. The first case was still successful because the Chinese agreed to the US request. So the payload suspended. And besides that, there are also 2 cases, DS 543 and DS 562. They got the final report, even it's lasted more than 2 years, but they got the final report. However, those reports couldn't become useful support paper, legal paper for the governments to take further actions. That's because they want to search a further legal make sure from the appellate body. However, as we know, 2 years before, the function of the appellate body has suspended. Why it has suspended? Because after the last judge term expired, the US used the recognition of the next judge. They used their rejection right to stop the stop the group members to circulate a judge successful. So the low judge could be selected further. That's low judge. The low one could work in the appellate body to give all legal support. So from this, we can see the imperfect system of appointment of judge, and as the recognition of appointment of a judge needs all the members to reach a consensus. So this rule is made hundreds of years ago. However, even it's out of date, and it's harder to change it because if the groups want to change this recognition, they need to reach a consensus again. So we can see the WTO in adequateness in trade rulemaking. So how to solve this problem? First, for time, we could refer to the Chinese Beijing court. They set up an internet court for the lawyers or the clients, the citizens to submit their request 24 hours without knowing that could to boost the cases be dealt faster. And for the judge, we could find Article 4 and Article 5 of Marrakesh Agreement established the World Trade Organization. There is a plurilateral agreement that regulate 2 to 3% of the groups of the members, the reach or consensus they could to make a regulation in their group. And then we could from this point we could find a way to solve the problem of appellate body. And after that, how to update our regulations of WTO, we could learning from USMCA, there is a sunset clause in their regulations that every 19 years the regulation have to be rechecked every 6 years. So if they only when the members agree this clause still useful and they will continue to use that clause, they could change it every 6 years. So to make a conclusion, I just figure out the from the US and China war, the cases that US and China submitted to the WTO and the present state situation of these cases. So from this phenomena and facts, calculate some force and to provide some suggestion of how to improve the situation of WTO appellate body. So I wish all this suggestion is useful. Thank you.